Yes, Mr. Post.
My lady, might I deal first with the page reference in relation to being put to Mr. Ivanov in relation to the claimant's case? My lady, that's at page 361 of the supplemental table. Internal page 7, when legal counsel for the claimant asked, would you accept a reasonable surgeon before the time of surgery? And Mr. Ivanov then answered that, and we come to the section at internal page 8, still on page 361, on which Mr. Stockwell relies, where a question is asked, a reasonable neurosurgeon before the time of offer surgery for that symptom will watch no for how long it's been present. I absolutely agree with that. And I believe that is the high watermark of the case as advanced. It says nothing, of course, about the wider case of Mr. Manhas not being able to inform himself and therefore not being in a position properly to advise as to the prospects for surgery and the prospects for the alternatives.
I'm just reading over onto page 9 to see the totality of the responses.
Yes, it is a very lengthy. It is a very lengthy answer.
So it said up to line 13 on page 9, in our scenario we had a different situation. That's from a soft disc herniation. We had a pain which was, in my opinion, it was there for a longer time, but it was documented in July. It's line 13 on page 9.
And page 10, at lines 4 onwards, various options have been explored. I don't think there were many other alternatives available.
So the expert view was that the pain had been there for a longer time, but first documented in July, and not many other alternatives were available.
There is a section which may be relevant to issues that are coming on to the bottom of page 10 as to how long it's likely the pain has been present.
At 14?
At 10.
At 10. No, page 10.
Yeah, internal 10 on page 316.
Yes, but is it line 14?
Yes.
Yeah.
It goes on line 20 onwards. Well, yes, from line 14 onwards, but right, it continues on to page 11, line 4.
Right. Thank you.
The next issue that I'd like to address is the proper approach of the court in these circumstances where the case that is now put was not pleaded, was not addressed in the expert reports, was not put to Mr. Minhouse and was only, perhaps the fairest way to put it is partially put to the experts. And my lady, in a sense, that's a very simple question, because of course breach of duty and clinical negligence is an expert issue. That is the Bolam. That is the whole basis of the Bolam case. It would be wrong in principle to conclude that the offer of surgery in the absence of inquiry or knowledge about the duration of associated pain amounts itself to a breach of duty, absent clear expert evidence to that effect. And in Mr. Stockwell's skeleton argument, he seeks to draw an analogy with a case called FB about the significance of taking a history. I won't seek to take the court to that case, but I make the obvious comment that in the FB case, there is expert evidence for the claimant dealing with the alleged breach of duty. It is not, as it were, a green light for the court to find that in different, but in some sense broadly analogous circumstances, the court can find negligence absent any expert evidence. But the next issue I should deal with is the appellant's criticisms of the judge's findings of fact about the duration of pain. The finding is at paragraph 87 of the judgment, and that finding, it's a core bundle, it's in the core bundle, it's at page 43 of the core bundle. Judge's finding is that it is not possible to say exactly how long the claimant had been suffering that terrible pain, but it was clearly acute and demanded some speedy intervention for its relief. It could not have been going on for more than a couple of months.
That final sentence reflects the agreed evidence of both experts.
Not entirely agreed evidence, because
well, one gave it, and then the other subsequently agreed with it.
Well, more or less, save that Mr. Ivanov did have the theory that ultimately the judge didn't appeal to the judge, that maybe it had been present at an earlier stage. That's the only reason. That's the only reason I didn't immediately say this. But in effect, yes.
Yep.
And my lady, in the light of the totality of the evidence, that was a finding that the judge was clearly entitled to find. And I mean, the basis of that evidence is set out in detail in the respondent's skeleton argument at paragraph 24.
I don't think that's how Mr. Stockwell's putting it, is it? What he's saying is, by saying it couldn't have been going on for more than a couple of months, the judge was specifically not finding that it was longer than 6 weeks. I think that's the way. I'm just looking for.
I think broadly that's right. But I think the starting point is that this is a finding to which the judge is clearly.
And he can't go behind it.
And he can't go behind it. Exactly.
And Mr. Stockwell accepts that. He's not sought to challenge that.
But yes. The next issue is whether there would have been any proper basis. And on this I have to concede the judge didn't make a finding, but the court would have to consider whether there would be any proper basis to find other than that pain must still have been present when Mr. Malik came for surgery on the 13th of August.
Before you move to that point, and it is exactly the point my lady has raised, are you going to deal with the point Mr. Stockwell raised this morning, that this finding, it could not have been going on for more than a couple of months, doesn't in fact take the matter as far as it's required to go? You're going to deal with that a bit later on.
Well, my lady, if if I may, can I deal with my point on the surgery? Because of course that adds another 4 weeks. If I'm right, as it were, if I'm right that the only proper finding would have been that the pain was still present 4 weeks after the first appointment, then, my ladies, my lord, the position is that the minimum period would be the 4 weeks between the 13th of July and 13th of August, together with whatever period of up to no more than a couple of months the pain must have been present for.
Doesn't that get you into difficulties about the fact that the date for the surgery was not fixed by way of a provisional date or with a sort of top-up assessment prior to the surgery?
Well, in terms of the top-up assessment, that was argued, and the judge ruled that wasn't an argument that was open to the
Right.
So the top-up assessment was effectively put aside. As regards to there being no formal assessment, well, part of what I say to that, my lady, is that, of course, part of the problem here is that none of this was pleaded.
Well, I appreciate that.
And that, therefore, although one might be critical of the absence of evidence from anyone who saw Mr. Malik on the day of surgery, on the basis of the pleading, it was not apparent that there was an issue as to that. Because on the basis of the pleading, the issue was as to the nature of the pain, and therefore the source of the pain, and therefore was surgery indicated to the thoracic spine at all. I mean, in those circumstances, this court should be very nervous of an argument that is critical of a judge, or indeed of a defender, or indeed of a defendant in circumstances where the defendant does not call evidence about a particular appointment whose significance was wholly opaque until partway through the evidence. And indeed his significance was not ever clearly put to Mr. Malik himself. I mean, logically, of course, Mr. Stockwell is right that merely to say it cannot have been going on for more than a couple of months is logically compatible with a period of significantly shorter than a couple of months. It is, however, not the language that would naturally be used by a judge if he were seeking to describe something that had just happened.
A sort of recent onset.
Something of recent onset, exactly. So it is simply not the language which is apt to describe an event as opposed to a condition. And the reason I was therefore going to deal first with the 4 weeks and then come back to this point is that if I'm right as to the only proper finding on the basis of the judge's finding of facts is that the pain remains present, then it would have to be of very recent onset indeed for at less than the 6-week point. And this court is entitled to say, reading that paragraph, that language is not apt to describe a pain that had recently developed. I mean, what I say as to the 4-week point is that the judge's findings of fact mean that Mr. Malik was fully aware that the reason for the thoracic element of his surgery was the intercostal pain, was the very severe intercostalgia. because Mr. Malik was perfectly aware that what was proposed was surgery at 2 levels, and perfectly aware too that the re-operation to the thoracic level was related to the pain, the intercostal pain reported that day. If that pain had resolved between the 13th of July and the 13th of August, it is inconceivable that Mr. Malik would not have reported that. And it's equally inconceivable that if he'd reported that he didn't have pain anymore, that the surgery would have proceeded as it
did. Isn't there a GP appointment between the 13th of July and the August operation date when analgesia is increased?
Maybe there was.
Yeah.
Or strictly it wasn't increased. There's reference to the fact that he's doubled his own dosage, as it were. He's been given a particular analgesic, and he says that he's up to the amount. My lady, on that question of the pain resolving, Mr. Malik signed a consent form which referred specifically to intercostal. Mr. Stockwell says to me that it was accepted that Mr. Malik wouldn't have understood what that was.
Sorry, for more accurately to say, it was accepted by Mr. Minhas that he wouldn't have used that term. It had always been Mr. Malik's position that he hadn't understood what that term was. He'd given evidence to that effect, but Mr. Barnes corrected the position because he put it to Mr. Malik on that basis that you knew what intercostalgia meant. It was in the consent form, and Mr. Minhas corrected the position, or at least told Mr. Barnes overnight. And so the first bit of the transcript on day 2 reflects the fact that Mr. Barnes quite properly said, actually, you know, I've been reminded overnight that Mr. Minhas wouldn't have used the word intercostalgia.
My lady, ultimately, a consent form is signed. It's a consent form that relates to surgery at 2 levels. Mr. Malik cannot have been in any doubt that the reason for the surgery at the 2nd level was the pain of new onset. On the question of the duration of the pain, it may also be right to take your ladyship to what Mr. Todd said about this in cross-examination at page 357 of the supplemental bundle.
Three five seven.
357 of the supplemental bundle. Internal page 81, where Mr. Todd says, but the intercostalgia was much more recent. We are not entirely sure when it started, but it may have been present for a couple of months. I mean, I have to be correct about the exact period of time. It's something of some weeks, a couple of months maybe, of intercostalgia. The next basis on which the claimant advanced the case below, and I think it's going to advance a case, is there a place for an adverse inference to be drawn in relation to the direction of pain? This is the principle in the case of Vishnevsky, which is in the authorities manual and divider at tab 15. This was the case involving a senior house officer who had seen the claimant but was not called to the evidence, and the issues arose as to the inferences that were properly drawn. My ladies, my lord, I simply take the court to the section of the judgment of Lord Justice Brooke, with whom the other judges agreed at page 304. Where Lord Justice Brooke sets out a series of principles, that in certain circumstances the court may be entitled to draw adverse inferences from the absence or silence of a witness who might be expected to have material evidence. But if a court is willing to draw such inferences, they may go to strengthen the evidence adduced on that issue by the other party or to weaken the evidence, if any, adduced by the party by reason of being expected before the witness. And thirdly, there must, however, have been some evidence, however weak, adduced by the former on the matter, or the court is entitled to draw the desired inference. There must be a case to answer on that issue. And my lady, paragraph 4, I think, is a bit of the principles. Principle 4 is, I think, less material. As to principle 1, I say, as I said a little earlier, that the defendant had no reason to expect prior to trial that there would be an issue as to the claimant's condition on the 13th of August. So it would be unfair to criticise failure to call a witness to give evidence, to draw an inference. But more fundamentally, the principle requires that there be evidence, there be a prima facie case from the claimant that is then strengthened by the inference. There is simply no evidence whatsoever here that the duration of the pain was less than 6 weeks.
So that's Lord Justice Brooke's third principle, is it? That you say
my Lord, exactly so.
that there has to be something.
There has to be something. It's not a.
And you say that on that point there's nothing other than.
My Lord, exactly so. There's simply nothing there. Yeah. And in the sense that the 6-week point arises essentially because of the way Mr. Ivanov put matters in cross-examination, not because there was freestanding evidence for less than 6 weeks, but simply that for forensic purposes it was necessary for the claimant to bring the period down to under 6 weeks. That's not a proper basis for an inference of fact to be drawn, because the purpose of the Wisniewski principles is not to simply to allow a claimant to come within a category where there's no evidence in support of that, but rather where there is evidence as to a particular state of affairs, evidence that might have strengthened that is wrongly not adduced or not made available, and in those circumstances the inference can be applied. That's a world away from the situation here. And therefore, what the respondent says is that although the judge's evidence is, it must be conceded, not as clear on the question of duration as in the perfect world would be, that would be the case. It is clearly apparent that he did not accede the claimant's invitation to draw a Wisniewski inference. It's clearly apparent he did not find as a fact that the pain had been present for less than 6 weeks. The evidence before him was indicative that it was not a pain that had arisen acutely, and the evidence of Mr. Malik undergoing surgery on 13th of August is an indication that the pain had not resolved spontaneously in that period. In those circumstances, the appellant does not make out a case that factually this was a pain that had only been present for a period of 6 weeks or less. The next topic I should deal with, which is a very brief topic, is the topic of the question of the pain experts and Mr. Stockwell's criticism that there was no finding as between the pain experts. The first observation is that the breach of duty issue in the case was a neurosurgical one. The evidence of the pain doctors was of little relevance to the central issue of whether surgery was indicated and whether Mr. Malik validly gave his consent to the surgery. There was in any event a measure of agreement between the pain physicians as to the issues that went to the judge's decision, and we see that from the sections of their evidence recited by the judge in his judgment. And that's at paragraph 73, at page 40 of your bundle. 5 lines down into paragraph 73, whilst he had a view as to the efficacy of each, he readily acknowledged it is unlikely that medication or other palliative rather than curative approaches as a primary treatment would have resulted in a satisfactory long-term outcome, as long as Mr. Malik believes thoracic spinal surgery to be the only long-term approach, successfully addressing and managing his ongoing pain problems. And then at paragraph 83, 2 pages further on, the judge summarised the evidence of Dr. Saunders for the defendant. He explained that techniques involving physiotherapy, occupational therapy, and pain psychology generally imply that the conclusion of interventional management, particularly surgery, and it'd be reasonable not to offer them until that stage in order to maximise their potential benefit. Patients tend not to engage with these approaches until they accept they face long-term pain, which they do not if they are aware there is a potential surgical cure. It was his opinion that in July 2015 there were no pain treatment options available that have been likely to have resulted in any significant long-term reduction in levels of pain or improvement of function. But what I say is to that is that there is there sufficient level of agreement between the pain physicians that it matters not that the judge doesn't make a formal determination as between their respective opinions, because their respective opinions are ones that are really, that's an issue I say merely background, but that the primary issue for the judge is of course the neurosurgical one, and the pain management issues are ones that merely set the context for the neurosurgical opinion.
Well, they set the context for neurosurgical opinion, and they can provide practical detail as to options. But the core expert evidence was that of the neurosurgeons, because he was a neurosurgeon whose actions or omissions were being scrutinised by the court.
Well, exactly so. And in those circumstances, failure formally to make a determination in relation to the pain physician evidence, in relation to which the issues are in any event, there's considerable amount of common ground, albeit there are specific areas of disagreement. Ultimately, that does not vitiate the judgment. My lady, unless there are specific issues in relation to ground 1, those are the respondent's submissions in relation to ground 1.
No, thank you very much. That's very clear, Mr. Post.
My lady, in relation to ground 2, I can be shorter because, in effect, there are 2 issues. One is the ground 1 arguments in a different context, the context of consent.
Kind of repackaged, aren't they?
Repackaged. Exactly so, my lady. The second is the argument that the judge did not properly apply the Montgomery case. And can I therefore start by taking your ladyship's and my lord to the Montgomery decision, which is in the authorities bundle at tab 2. Might I start at paragraph 82 of the judgment of Lords Carr and Reed, with whom Lord Newberger, Lord Clark, Lord Wilson and Lord Hodge all agreed. And I think if I may, I will start at page 52, the two letters A and B, which is paragraph 82. They, in this case, that being the claimant, point to a fundamental distinction between, on the one hand, the doctor's role when considering possible investigatory or treatment options, and on the other, a role in discussing with the patient any recommended treatment and possible alternatives, and the risks of injury which may be involved. The former role is an exercise of professional skill and judgment. What risks of injury are involved in an operation, for example, is a matter falling within the expertise of members of the medical profession. But it is a non sequitur to conclude that the question of whether the risk of injury or the availability of an alternative form of treatment ought to be discussed is also a matter of purely professional judgment. And then, of course, that feeds through to the judgment and to the determination that as regard the latter, the test is of materiality, not the Bowman test. That, of course, is the ratio of the decision. But a distinction is being drawn between two categories of professional skill. That the former role, assessing which alternatives are available, which treatments are available, treatment options, is contrasted with the latter, which is a category to which the materiality test applies. I mean, we say, Mr. Stockwell said that there was suggested that there was a suggestion of a gloss being added to Montgomery to say that a Bolam test can apply to these questions. I mean, it's quite clear the gloss it's not a gloss because it's in the judgments themselves. It's in the judgment that there are two roles on the part of clinicians in relation to the one role the usual professional skill applies, in relation to the latter role of which options to discuss, and which options to disclose, it is in relation to the second that it is necessary to apply a test other than the bone test. And we see that if we therefore read on to the core of the decision on the next page, on page 53, the correct position in relation to the risks of injury, and then at 4 lines below letter B, the doctor is therefore under a duty to take reasonable care to ensure the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatment. Now, my lady, we say that the use of the word reasonable alternative or variant treatments, makes it clear that as regards alternative or variant treatment, one is in the first category in paragraphs 82 and 83 of the usual exercise of professional skill and judgment, and in relation to the material risks, one is not in that regime, but instead in the separate regime of materiality, which is to be judged from the perspective of the patient.
I mean, the point of this was what it was recognising was the autonomy of the patient.
Exactly so. Exactly so.
And thus departing from Sidra.
But it is exactly so. And it is in no sense necessary in order to recognise the autonomy of the patient that the alternatives to surgery should be chosen by the patient too. Self-evidently, it's the doctor who assesses whether reasonably what alternative on the basis of his professional skill, and it must do it reasonably obvious, clearly, assesses what the reasonable alternatives are. It cannot be the case that merely because a patient might wish for there to be an alternative, that is then rendered a reasonable alternative. I mean, it would be very, very hard to imagine what the word reasonable could possibly mean in paragraph 87 if it does not mean reasonable in accordance with both. We therefore say that the way that the judge dealt with this in the judgment, which is at paragraph 93 of the judgment, page 44 of the court article, my lord, we say that the way the judge deals with the issue of Montgomery in paragraph 93 entirely reflects the guidance in paragraph 87 of Montgomery itself, and that Mr. Stockwell's criticisms are quite wrong. That approach entirely accords with the guidance of the Supreme Court. Might I finally turn our issue of causation? And I should make clear that the respondent's position is that even if, contrary to the previous submissions, there was a breach of duty as regards either the extent of Mr. Minas's knowledge when he offered surgery or the validity of consent, the claim would still have failed and the appeal should still fail on the issue of causation. And the judge's findings on causation are at paragraph 94 and 95 of the judgment. And at the end of paragraph 95, the judge found that Mr. Malik wanted this surgery in order to relieve him of his terrible pain, and he wanted it quickly. And that's the background to his conclusions in the previous 12 lines or so, as to why the judge would not have found that any negligence was causative of the injuries, and that he would not have declined the offer of having surgery if other options had been explained to him, and indeed at paragraph 94, that if the defendant had been negligent in any of the pleaded particulars, he would not have found any negligence caused the injuries because the surgical intervention was a reasonable course to advise given the available evidence. There is, of course, no appeal against the finding of fact about Mr. Malik wanting to have surgery to relieve him of his terrible pain. He wanted it quickly. There couldn't be, of course. Instead, what Mr. Stockwell appears to be suggesting this morning is that there is some case that the claimant would in fact have got better. But I confess, although I noted it down at the time, I had difficulty discerning what the evidential basis for that contention might have been. It didn't accord with the expectation of the experts that there wouldn't be a spontaneous resolution. The evidence experts, there wouldn't be a spontaneous resolution. Nor does it accord, nor did Mr. Stockwell identify any specific evidence that should lead this court to that finding. I don't think I can address the point further. To be truthful. What we say too is that even if, contrary to the respondent's case, there was any basis for postponement of the surgery, if one postulates a particular sequence of answers such that it emerged that the date fixed for the surgery was less than 6 weeks after the onset, that if one postulates a delay in those circumstances, there is no evidence that the risks on a later occasion would have been any different than if the surgery had taken place on the 13th of August. Mr. Stockwell submits in his supplementary skeleton that the court owes no fidelity to the judge's finding as to what Mr. Malik would have done. But that's not right, because of course the judge is the one who saw and assessed Mr. Malik and came to conclusions about the pain he was suffering and what he would have wanted to happen about that pain. And this court is in no position to substitute its own view and simply doesn't have the material for it that would allow it to do so. Maybe the two cases that the claimant relies on in relation to causation are the case of Crossman and the case of Chester. And Crossman is at the authorities bundle at tab 4. And it's a decision of his honour Judge Peter Hughes, sitting as Deputy High Court Judge, Paragraph 2 of the holding on page 95, we see the basis on which the judge found that on the balance of probabilities, had the operation taken place on a different occasion, although the risk would have been no greater, on balance the risk would not have eventuated, and therefore the claim was able to succeed on the basis of conventional but-for causation. My lady, we say that argument is simply wrong. We say this court should certainly not apply the case of Crossman. Judge went on to say that the claimant couldn't bring himself, could not come within, could not bring himself within the modified Chester and Elshire test. And we observe that the modified Chester and Elshire test would not need to exist if it were the case that merely saying that a patient would have postponed surgery would be enough to mean that on balance injury would have been avoided. And we see that from the judgment in Chester itself at the previous divider. And my ladies, again, can we start with the holding and paragraph 1 of the holding on page 61. Since the judge had not found it properly informed, the claimant would never have undergone the operation, and since the risk which eventuated was larger would go around them, irrespective of skill and care with which the operation might be performed, defendant's failure to warn neither affected the risk nor was the effective cause of the injury. She sustained, so that applying conventional principles, she could not satisfy the test of causation. And we say that is the answer, is a complete answer to the holding in the Crossman case, because that is effectively the same. That is effectively the same argument as the argument that succeeded in the case. Mr. Stockwell then sought to say that if this court was in doubt as to what would in fact have occurred and what Mr. Malik would ultimately have been decided, there would be an opportunity to treat Mr. Malik as in the same category as Mrs. Chester, and therefore apply the special rule in Chester in order to allow Mr. Malik's case to succeed. And my lady, as to that, I take your ladyships to paragraph 24 of the judgment of Lord Justice Steen. Standing back from the detailed arguments, they have come to the conclusion as a result of the surgeon's failure to warn the patient, he cannot be said to have given informed consent to the surgery in the full legal sense. A right of autonomy and dignity can and ought to be vindicated by a narrow and modest departure from traditional causation principles. And that narrow and modest departure from traditional causation principles is predicated on the very thing about which warning should have been say the breach of autonomy is the failure to warn, and that is so closely related to the occurrence of the very thing that should have been warned against. That in those circumstances, it is proper for the courts to depart from conventional causation principles to find the breach is sufficiently intimately related consequences. My ladies, my lord, we're not even a million miles of that principle here. The cases of a failure to take a history, not of a warning, and the suggestion is a widening of that narrow and modest departure into the field of history taking, which would have the potential consequences that the narrow and modest departure from the general rule could in effect become the general rule. And there isn't a proper basis for saying that the breadth of the principal in Chester should be widened. One would need an order, powerful reasons in order to expand the special rule in Chester to completely different circumstances. Can I summarise the respondent's position on causation there? It is this. Whether or not your ladyships conclude the judge's determinations regarding the issues of breach of duty and consent were incomplete or flawed, the appeal should still be dismissed because the claimant cannot make out a case on causation. I say that for 5 reasons. The first is that the claimant did not give evidence that he would have elected to defer or reject surgery if told something different about the balance of chance of success.
Sorry, can you just slow down?
I do apologise.
It's all right.
Claimant didn't give evidence
Yes.
that he would have elected to defer or reject surgery if told something different about the balance of chances of success due to the duration of the pain. The second reason is that the judge expressly rejected the claimant's case that if other options were explained to Mr. Malik, he would have declined the offer of surgery, or would have sought a second opinion, or would have deferred the decision. Thirdly, even if there was to be a finding that Mr. Malik would have deferred surgery, the agreed evidence was that alternatives to treatments would have failed. And I've taken the court to the sections in the judgment where the judge summarised the evidence from Dr. Valentine and Dr. Sanders. Therefore, my point 4 is this patient would have come to surgery following the failure of alternative treatments. And fifthly, that if the claimant came to surgery on a different occasion, there was no evidence before the court that the risk would have been any different on that different occasion. In summary, the neurological damage that Mr. Malik suffered was not a consequence of the advice that Mr. Minhas gave, but of the surgery that Mr. Malik wanted. that surgery not being wanted by Mr. Malik, it was required to treat his terrible pain and would have been required even if it was not performed on the 13th of August. Ground 3 should therefore be dismissed, and with it, the appeal should be dismissed. Are there any?
No, thank you very much indeed, Mr. Pace. Yes, Mr. Silkwell, anything in reply?
I just briefly deal with some matters. Just to respond specifically to the forensic point made by my learned friend about where things appear in various documents. I do recognise, with the benefit of hindsight going to this stage, that yes, it probably would have been more helpful for this court to have had one composite document that had the remaining issues in the claimant's opening and closing documents before the trial judge and the appellant skeleton for this court in one document. I do
managed.
Well, I'm grateful, my lady, but my own friend makes various points about there not being evidence in, or references to evidence in the appellant skeleton and the supplemental document, and that's correct. But they cross-reference back to the documents in which the evidence is fully referenced, and the claimant's, or the appellant's position rather in this court is that various things that were raised before the judge, both in written format in those documents and in closing submissions, were either not dealt with correctly or not dealt with at all. And so it's in those circumstances that the court has to read the documents as a synthesis. I accept that there have been different ways in which the criticism or difficulty that we say there is in the way that Mr. Minhas conducted the consultation has been framed in different ways, both below and in the appeal. The problem is the gap in the information, and you can criticise the surgeon for proceeding against the background of that gap, or you can criticise the gap arising in the first place, but effectively it's the same criticism framed in a different way. The problem is the gap. There's a question about what was done in the knowledge that there was a gap, or in circumstances where it ought to have been appreciated that that was a gap. And there's an issue about how the gap arises. The problem is the vacuum or the gap that placed, we say, Mr. Minhas in a difficult position, justifying the position that he did. Again, an issue is taken in relation to what in particular Mr. Todd did or didn't include within his report. Now, we say, as I've said in submissions in relation to the pleading point, that there was no reason to suppose that Mr. Minhas would not have inquired about the duration. We do say that that is a new feature, or a new facet at least. It's said by Mr. Post that, well, just look at the clinic letter, that doesn't mention the duration. But equally, the difficulty with that submission is that it doesn't mention a lot of things that Mr. Minhas went on to say in his evidence. In particular, it doesn't mention anything about the discussion in relation to the risks associated with surgery. Mr. Minhas gave evidence about that in his witness statement. He amplified that evidence in the evidence that he gave in court, and the court accepted that evidence. But it's not right to look at the clinic letter and say, well, hang on a minute, that doesn't say anything about duration. So you can have inferred from that clinic letter that is something that he didn't ask about or didn't get an answer from Mr. Malik about, because it really can't be the case that the respondent can have it both ways. It was also said that the whole of the claimant's team should have been aware about the duration point. But then equally so of Mr. Ivanov, and obviously he's in a different category, being a Part 35 compliant expert. So it may well be that it's the case that the defendant in a particular case might let sleeping dogs lie if a party doesn't turn their attention to a matter. But certainly the same can't be said of Mr. Ivanov in discharging his duties to the court. Mr. Post then goes on to say, we don't know what Mr. Don't know what Mr. Minhas would have said if it was specifically put to him that it had been negligent not to inquire as to duration. A couple of points to make in relation to that. It suggested that he may have been able to explain it away, but no explanation or possible explanation is actually posited by the respondents. And obviously, if we look at the evidence that was given by Mr. Todd and Mr. Ivanov on this, and neither of them came up with an explanation that was exculpatory or explained the failure to add. And indeed, there's some unfairness in this regard, in that that was the way in which the questioning of Mr. Todd was actually framed. So if the court can look at the bundle of transcripts, cross-examination, so it's in the page 109 of what will be day 2, internal pagination 194 to 195.
Sorry, Mr. Stockwell. Day 2.
It's a cross-examination of Mr. Todd on day. Which will have been day 2. Just let me double check that reference for your lordships.
I thought he was 3, day 3.
I may well have got myself muddled here. He was. I think he crossed over from one day to the other.
Oh, you, yes. So what was the page?
Sorry, my lord.
That's right.
I'll give you that in a moment. It's transcripts bundle 109, and the internal page reference is 194 to 195.
Yeah. So that's the end of day 2.
Yeah, that's correct. And this is my learning from Mr. Barnes's cross-examination of Mr. Todd. It's put to him on the basis that the duration was a relevant question to be asked.
So we've got the answer on page 195, starting at line 3. Having been asked whether it would involve questions about duration and nature of pain, and replies, yes, the duration and location, but particularly to make this distinction, the quality of pain.
Yes, my lady. That was because Mr. Todd's evidence had been that it was necessary to differentiate between radicular and neuropathic pain on the agreed basis that one was amenable to surgery and one wasn't. But the ultimate position was that Mr. Todd accepted that it was actually difficult to differentiate between the two, and that was the position that was advanced by Mr. Ivanov. And in effect, it was a fool's errand to start trying to differentiate between the two, so that part of Mr. Todd's evidence fell away.
I
not attracted to the idea of making kind of forensic points the other way in terms of who did or didn't ask various different questions. But I do make the point that the defendant did not re-examine Mr. Minhas in relation to this point, and the difficulty with saying on the one hand it wasn't a new point, it was all part of the evidence that was there to be considered, is that cuts both ways. So if it was always something to be considered and it was something that Mr. Minhas had given new evidence in relation to, then the opportunity was there to explore it. And the reality is that it was the area was deliberately left well enough alone because Mr. Minhas's answer to my learned friend Mr. Nifton's question wasn't particularly helpful to the defendant's, as it were, case. But
it's always a little difficult, isn't it? That the submission you just made saying, well, that could have been the subject of re-examination, because obviously it's a long time ago since I ever considered re-examining anybody. But I was always taught count to 10 and don't do it.
My lord, that had always been my approach to it until I was sat behind Sir Geoffrey Nice in a 2-week trial, and he managed with his considerable general advocacy experience to elevate it to a fine art. But it's something that
was never
people at the civil bar don't generally touch with a barge pole for the reasons that my lord has quite rightly indicated. But as it may well be that court thinks there's less force in that point as a consequence.
I think the difficulty you have is it was just one answer. And if there's one answer, I mean, I have to confess, I was in the same camp as Lord Justice Coulson that you don't touch in re-examination unless there's a very, very good reason to do so. And we've got one answer, that doesn't sound to me like a good reason to wade in re-exam.
Well, that brings me to the next point, my lady. I mean, the reality is the answer was given, and whether it was the source of a whole series of questions relevant to that issue, the answer or the taking the course that answer made clear is just not one that's logically defensible. So to some extent there's a circularity to all of this. If you accept that there might have been a possible explanation to it, there might have been something that might have been conjured, then you'll be against me. But the reality is that there was no answer that I can fathom, or the court might fathom one of its own, and certainly one's not been posited in this court by the respondent as to what might have been said. It's just not something that's logically defensible not to ask somebody if somebody complains of something to you, at least, as a new presentation or a new symptom. And so the reality is there was nothing that could have been said by Mr. Minhas, and failure to ask that question was not objectively justifiable. And to some extent, the expert's view on it would have been neither here nor there. I mean, it would be fairly and squarely within the litho territory not to ask somebody how long they'd had a problem for. It just flies in. I mean, it was that to say is the background in which we say the approach, or Mr. Minhas approached the matter. He was equally desperate for different reasons to try and assist Mr. Malik, but that willingness or that enthusiasm to do that led him into error. The other point in this context, which I was coming to, is the idea that the alternatives were not fully explored, or that against the background of the duration point. I'd ask you to because I think it's the only fair way of dealing with the situation, to read the cross-examination, or indeed the examination, cross-examination and re-examination of Mr. Minhas in full, because I think to adopt what my learned friend said in relation to the importance that he would attach to that, it seems unfair to everybody in the circumstances. It's unfair to the court to be asked to do it, I accept, but it seems unfair to do it in any other way rather than just look at snippets of that evidence. But in particular, if I can ask the court to take a look at It's in the start of this questioning by my learned friend Mr. Nifton was in the transcripts bundle at page 97. It's day 2 and it starts at internal page 145. I don't need to take the court necessarily to it now, but if you want to take a look at it, I'll be glad for you to do so. But this is the start of him, that is Mr. Nifton, taking Mr. Minhas all the way through the various different options. And he prefaces his cross-examination on the basis that this was a new symptom.
So you want us to look at that as a part of the.
I think that's the most helpful way of doing it. But that the start of the entire the entire evidence, oral evidence of Mr. Minhas, or properly, in fairness to everybody, be considered by the court. And I accept that's something of an indulgence to me because I'm asking for it, but to the parties generally. The particular point there that I've referenced is the bit where Mr. Nifton says that, I'm prefaces the cross-examination in relation to the alternatives on the basis that this was a new complaint. So, with respect, it's simply not correct to say that the significance of the new onset was not figurative in the cross-examination, that Mr. Minhas didn't have an opportunity to respond to it. So whilst I'll happily accept some criticisms of the pleadings, I'm less ready to accept any criticism on the part of Mr. Nifton for how the cross-examination was conducted. Obviously, I can't apologise in his behalf in any event. My lady, I accept the general proposition about the need to be fair, and to some extent that's all the cases I speak to in terms of putting various different things to witnesses. But we are in the relative, slightly unusual situation of this being a case against a trust, and Mr. Minhas being obviously an very important witness in that process, but he wasn't the only witness to it, and this through a combination of putting the facts to Mr. Minhas and putting all of the issues to Mr. Ivanov fairly and squarely, there is no unfairness in relation to how the matters were explored. The point about professional imputation or professional reputation has a superficial attractiveness to it, but it must be a non-point for the following reasons. And I say this against the background of having acted for and against lots of employers and employers' liability context, lots of local authorities in that context. Somebody who is criticised for how they have or haven't done their job feels no less happy about the situation, or no less happy about a finding being made against them, than somebody that happens to discharge their role in a professional capacity. There are different implications for people making complaints in different contexts, but within civil proceedings, if a criticism is made of a doctor, they don't have a special status, and so as I say, this, although superficially attractive, fairness dictates that you put the requisite amount of informational questions to each of the witnesses, irrespective of their professional status. And as I say, with respect to the points that have been made, that was done in this particular case. My Lady Justice Davies made reference in the course of my learned friend's submissions to a GP reference. If I could just give you that reference. Oh, sorry.
No, I'm very grateful.
It's a supplemental bundle, page 6. If you note it. Supplemental bundle, page 6. It's the extracts from the records. The only point to make specific in relation to that, my lady, is that obviously it doesn't reference intercostal symptoms. It references the pain and symptoms that were previously referenced with the up of the left lower leg. There were some additional symptoms around the midriff, but not ones which could properly be said to be around the chest region that we were looking at. So,
well, he actually went for a complaint about his mouth, didn't
That's correct, and ended up getting examined for something completely different. So certainly that examination was above and beyond the call of duty, my lady. Yes. The other document that was referenced was the consent form, and I've already dealt with, but by way of interjection, the point about Mr. Minhas having accepted both in evidence and through Mr. Barnes that he didn't use the word intercostalgia. So Mr. Malik's position had always been that he didn't understand what that term meant until some way through the course of the litigation. He said that in his witness statement, he said that in the course of his oral evidence. And quite properly, Mr. Barnes corrected the position overnight and said, well, no, actually, Mr. Minhas accepts that he probably wouldn't have used intercostalgia. He would have tried to explain it in lay terms. But the difficulty allied to that is that, of course, the consent form itself, which the court will find at supplemental bundle page 46, is not readily legible, and indeed Mr. Minhas, who wasn't responsible for completing it, had difficulty reading it himself in the course of evidence, and the reference to that is on day 2, internal reference 162, 163. I don't need to take the court to it, but essentially he had to have it decided for him. Probably a combination of having to be on Zoom or whatever medium we did it, but it wasn't readily intelligible. With reference to the point that Leonard Friends the place makes about there being no reason to suppose the presence of symptoms on the 13th of August 2015 would be an issue, well, that simply can't be right for a number of different reasons. First of all, consent was an issue for the 13th of August. The defendant in the trial elected for whatever reason not to call any evidence in relation to the 13th of August and how that exercise was conducted, albeit obviously it was expressly a pleaded part of the claimant's case. I've already made the point, but just reiterate it in this context, that of course consent is a continuing duty. It's not something that one obtains on one day and can necessarily rely upon a month later. If it's reasonable to expect the surgeon to satisfy themselves, it must be reasonable to expect the surgeon to satisfy themselves that the conditions for surgery still pertain on the day that the surgery is to be performed. Now that would be accurate as a general proposition, because there can often be a significant interval between somebody having a recommendation made to them and actually ending up having a procedure. But it must particularly be the case in these circumstances where there was that inherent uncertainty. Okay, it wasn't an uncertainty that Mr. Minhas attached much significance to himself, but objectively looking at the position, as one would need to do in terms of looking at what evidence was called, that must be the case. Now, the only point on which I might also be able to help the court with it is in relation to the Chester point. Again, there's a difficulty with the way in which the case is put for the respondent. I fully accept that the context in which the Chester modification arose was in the context of the risk of the procedure and the one which actually materialised, not being explained. But here we've got a position where we're saying, and obviously it's entirely dependent upon whether or not the court accepts this, that the recommendation for surgery shouldn't have been made in the absence of this gap. So of course, if the surgery hadn't been recommended, then none of the risks attendant would have been materialised. So it would be a fairly anomalous position if somebody that had a discrete risk that wasn't warned about found themselves in a better position than somebody that shouldn't have had the procedure in the first place. With all the attendant risks associated with it, it's an illogical position to adopt. I appreciate that Chester is framed in that way, but it must be the case that the bigger picture is more important because it's more of an affront to consent to proceed in the circumstances where the operation wasn't indicated, at least at that time. This point, last point in relation to causation, the claimant would have come to surgery after conservative measures had failed. Well, that wasn't pleaded as it should have been. If a defendant is going to make an alternative case in relation to causation, say, well, let's suppose we are wrong in whether or not the conditions for surgery were met on the 13th. They were met on the 13th of July, that is, but they were met on the 13th of August. Then that is something that should have been in the defence. The defence is entirely silent in relation to that. So whatever source of the goose, as it were, must be source of the gander. So if the court accepts that the recommendation for surgery should be made, then effectively we're still left with the very same gap about what would have happened. But the evidence, contrary to what's been submitted, was clear that there was a small but real possibility of spontaneous resolution. That was the clear evidence of the experts. The references are in the documents that were available to the trial judge. But certainly the other alternative strategies, although not necessarily guaranteed, had some prospect of either improving the position or addressing the position, the difficulties in its entirety. I don't propose to take you through all the references that were relied upon in terms of the alternative treatment measures. But it brings us back to this question, which to some extent aligns with what Dr. Sanders said. We don't know how Mr. Malik would or wouldn't have responded. So either a brief period of wait and see, or any of the treatments that were indicated. We don't know because that's not the course that was taken. So he might have been the 1 in, or the 5 in, or the 10 in. However many people would have had a resolution or a curtailment of their symptoms during that period. We simply don't know because he simply wasn't afforded that more cautious approach. If there were, but what you wouldn't do, and which is why the court might be attracted to what Dr. Sanders said, is one doesn't just say that this claimant wouldn't have had a good outcome just because X number of people would have derived limited or no benefit, because he had his own opportunity, he had his own chance of having a more significant outcome, and in circumstances where he was deprived of that opportunity, then he is fairly and squarely in the Keith territory that's been referenced by my learned friend. If we don't know because of some underlying failure on the part of Mr. Minhas, then he's entitled to a benevolent assessment about where he might have ended up. It's not dependent upon him having been able to demonstrate any injury at all. It's just a peculiar remedy to meet a peculiar injustice that would otherwise arise in circumstances where he didn't have the benefit of a more conservative approach to his treatment. Malady, is there anything else that I can help with that arose out of my learned friend's submissions?
Yes. No, thank you very much indeed, Mr. Stockton. Well, thank you all very much indeed, both you and counsel behind you and your instructing solicitors and people who have helped put the bundles and so on together. You won't be surprised to hear that we will reserve our judgments and we will get them to you as soon as we can, but we don't make any promises as to precisely when that will be. They'll come out to you in draft form. That's for typographical, grammatical and minor factual errors. It's not obviously an opportunity to re-argue any of the points that you both so skillfully argued before us already this morning and this afternoon. Please note the new terms of the embargo that appear at the oral judgments now, and supply the list of those who will be have an opportunity of seeing the judgment in draft. I suppose that is particularly the case with your team, because I think it marks such a very quite dramatic change in the way draft judgments are handled, and sometimes people feel a bit left out, that they're not allowed to see the draft judgment, but you'll appreciate the importance of maintaining the integrity of the judgments till hand down.
Yes.
Then if we can then deal with any orders in writing, please. If there's any arguments as to costs or any other ancillary matters, then we'll have submissions in writing and deal with them on paper. So thank you all very much.
Thank you, Maggie. Hey, Maggie.